Hello, everyone, and welcome to our distance learning version of our key legal concepts for this week. Sorry about everything having to do with the virus. We're doing the best we are doing the best we can here to try to make sure we cover everything in this distant learning format. So hopefully this works. I will go through the key legal concepts here, and there's a forum on Sakai that you can use for questions. And I'm hopeful that we were able to match the learning objectives doing it this way. Okay, so let's get on to it because I think I'm going to go through every one of the key legal concepts. I'm going to do it kind of briefly. So if you do have questions, let me know. And these slides will be available. I'll post them on Sakai also when I'm done here. Okay, so week 6 legal concepts. Now, this chapter from Shell this week is incredibly important because it is the chapter that describes how lawsuits actually work, the order and the flow of them, and how you go from filing to trial. And it's important to know because most cases, as we'll talk about, don't make it to trial. So it's really important to understand the steps along the way so that you can make good business decisions about when and whether to try to settle. But the problem with this chapter is that there are a lot of technical terms. So in one sense, the fact that we're doing this online this week is actually helpful because I have a chance to go through each one and I don't have to worry about running out of time. The other thing about this chapter is it's the last chapter of part one. Part one having to do with how rules are made, and then starting next week, the shell material changes from this background material about how laws are made to how to actually use them to your advantage. And then the last note here, please make sure that you use the forums. I will monitor them all day, every day. So if you have a question, please post your questions there. Okay. All right, so let's get right into it. The first one is, what is a class action? And if you've ever received one of the notices in the mail, I have copies of them in my office, but I'm at home, so I don't have them here. But if you ever received one of these notices in the mail that says that you are part of a class action for some kind of product that you bought or service or whatever it is, that's what a class action is. Effectively, what it is it allows a group of people to sue one defendant and consolidate all of their claims into one large claim. I'm going to jump around here a little at the third bullet point here. Actually, let me turn on. Let me turn on my pointer. Okay, here we go. Pointer. Okay, so this right here. This last bullet explains why we have class actions in the first place. The classic example of this is that the consumer suffers a dollar loss. Well, nobody's going to sue for a dollar loss. And we might not care if somebody suffers a dollar loss. It's not worth burdening the legal system. But what if 1 million people suffer a dollar loss? Well, that's $1 million worth of damage that a defendant is creating. But because it's spread out over so many people, there's no real effective remedy for that loss. So that's what class actions do, is they give plaintiffs the ability to combine together and sue as a group. There's an example. A client of mine got sued in Pennsylvania. There's a law that says you can't send a fax to anyone without their consent. And this law dates back to the 90s and 80s even, when fax paper was thermal and was very expensive. And so people started faxing advertisements. And the idea was, well, the recipient of the advertisement is paying to receive it because of the cost of the paper. So, but the federal government didn't have the resources, the federal or the state governments didn't have the resources to go pursue people who were sending unwanted faxes. So they just created a law that says if you get one of these faxes, you can go sue the person who sent it to you for $500 per fax. And this is what we call a private right of action, giving the giving the customer the right to pursue this claim independently. But again, $500 isn't that much money. But if you match together everyone who receives an unwanted fax, it can be a lot of money. And I had a client who used the fax as a way of advertising his business, sent some unwanted faxes to his customers or potential customers in Pennsylvania, and was sued by this lawyer and plaintiff pair who had sued 22 other companies before us and sued us for $5 million. Ultimately, we settled for much less than that, and the lawyer got $100,000 for it, and the named plaintiff got a few $1,000s. So this is how you can harness these laws, use these laws. The government uses these laws to have to give people enough reason to go after people who are breaking the law. Okay, so what are the requirements for filing a class action? You can't do this just in any case. So there are these four main requirements, which come from Rule 23A, the Federal Rules of Civil Procedure. And the first one is what we call numerosity, which there has to be enough people for this to work. And in this case, they define that as 40 people or more. There has to be commonality among the loss. So pretty much the idea is you're only going to have one case. So the case has to be the same for every member of the class. If the loss is unique from one member of the class to another, then we don't have commonality, and each of those plaintiffs need to sue on their own. So the only way you can sue as a class is, I realize my hair is sticking up. The only way you can sue as a class is by having the same kind of injury. Typicality, so is the same. The ruling or requirement there is that whoever the class representative is, so anytime you have a class action, there's always one member of the class who's actually what we call the named plaintiff. They're the ones who actually bring the case. Like in my fax example, the one person who received the fax, and they sue on behalf of everybody else. And so the named plaintiff has to be the representative of the class. And then lastly, the lawyer has to be appropriate. Not just any lawyer can file one of these things. And if the lawyers have conflicts or other reasons why they can't participate in this one particular case, it's just a way for the judge to ensure that the representation of the class is proper. If you meet all of these standards, then the case is what we call certified. It's a certified class action case, and then it can proceed forward as a class action. So the very first battle in a class action is whether to certify the class, and the defendant, of course, uses these arguments to try to argue that it doesn't satisfy class action requirements. Okay, so that is a class action or a class action lawsuit. All right, let's move on to a summary judgment. So what is a summary judgment? Well, this is a judgment that the judge makes before a trial, awarding the case, declaring the winner before a trial. So now you might think, well, why would you do that? If that was the case, why would we ever have trials? Well, and the point of a summary judgment is to relieve the legal system of cases that don't really need a trial, where there's nothing that could come out of a trial that would help. So the judge rules based on the evidence that exists at that point. And so this comes from Rule 56, which, again, all these rules, when these numbered rules, these are from the rules of Federal Rules of Civil Procedure. We'll talk about what civil procedure means in a minute, but this is the rule book that determines what can and cannot happen in a federal case, and the states have rule books that are very similar. And there's even actually local rules, depending on what court you're in. different rules in King County, for example, than in Pierce County. But anyway, what a summary judgment is it's a motion by either party, but usually the defendant, or I'm sorry, usually the plaintiff, to award the plaintiff the judgment even without the trial. And you'll see this here. The key issue is, are there any material facts? So remember, we talked about this before. The trial court's job is the finder of fact. That's what happens at a trial. Both sides present their evidence, and where the evidence conflicts, it's the purpose of the trial court to decide what the evidence is. And so if that's not necessary, if the evidence is so obvious that we don't need the trial to determine the facts, then we can have a summary judgment. It's a way to clear the case, get rid of the case before trial on the argument that no trial is necessary because it won't find any fact that doesn't already exist. Okay, so these judgments or these motions for summary judgment are filed after discovery. And we'll talk about discovery in a minute. That's all the fact finding that happens prior to trial. But this happens before trial. So after the discovery is completed and before trial, that's when you would see a motion for summary judgment. And in really big cases, there's almost always a motion for summary judgment. One of the two parties is going to argue that the case is so obviously in their favor that the judge should award them a judgment, and either the plaintiff a judgment or the defendant the win. So that's when they're filed. They're hard to win, though. Judges are not very agreeable to eliminating a trial unless it's just really obvious that a trial is not necessary. Okay, that's summary judgment. All right, let's move on to arbitration. You may have heard of arbitration before, but basically it's a form of alternative dispute resolution, or ADR as we call it. And by alternative, we mean an alternative to going to court. So it's generally considered less expensive. You see this down here on this low here. It is less expensive. It's usually private, whereas everything that happens in a typical court case, in most court cases, is a matter of public record. So it's a way for litigants to keep the dispute private. And the discovery rules are more limited. So, and as are the evidentiary rules. The whole idea is to streamline a case and to have a third party rule. So you actually, in arbitrations, you will have a judge or a panel of judges who will decide who wins and who loses. There's versions of it which are binding. So a binding arbitration means whatever the arbitrator or arbitration panel decides is the final rule and there's no appeal. And then there are non-binding arbitrations that can be appealed into the court system. This link here is to an article from the ABA about arbitration, in case you're interested. The ABA is the American Bar Association. And it kind of talks about the sort of difference between the kinds of arbitrations that are available. They come in different flavors, different formats, different costs. But generally, the parties like large, big businesses generally prefer arbitration because, again, it's lower cost, more predictable outcomes, and private. So you see this a lot in things like securities. If you're suing your broker, your stockbroker, for example, that will be you will have signed a contract when you open the account to agree to mandatory arbitration. So there are some companies that really prefer these forums instead of the courts. There's some controversy over. Oh, sorry about that. Hang on, I'm going to pause this and deal with the phone, otherwise it'll just keep ringing behind us. I'm back. Sorry about that. I don't know why we even have a home phone anymore, except that it comes with Comcast and Anyway, okay, so I was talking before the phone interrupted us that big companies like these and arbitration clauses in contracts that require this, but there's some controversy about using them in contexts like employment. So if many employers will have in their handbook that if you want to sue them, you have to arbitrate, or it'll be in the non-disclosure agreements or whatever else it is. And there's some effort in some states to limit that, because the argument being that employees don't really have the power to negotiate the terms of their employment, whereas in a business to business contract, the parties can negotiate whatever they want. So it's a form of avoiding all of the cost of litigation, or some of the cost of litigation, and receiving a more predictable outcome with in a private setting. Okay, so that's arbitration. Let me click over to the next one. All right, venue. This term venue, when we think about venue in the generic term, you think like a concert venue, right? It's a place where you hear a concert. Well, this is similar in a lawsuit. The venue is going to be the court that hears the case. And we've talked about this a little bit already in previous weeks, but litigants can pick their venue sometimes. There are sometimes multiple courts that will have the jurisdiction over a case. And so the plaintiff can often select the venue or the court that he or she thinks is going to be most favorable to them. So the plaintiff can't pick any court, of course. And this is the question here: can a plaintiff pick any venue that she wants? And the answer to that is no. It can't be any venue. It has to be a venue that has jurisdiction over the case. So I can't, if I'm having a dispute with my neighbor, I can't sue him in Florida to try to make him incur the expense of going to Florida as a tactic, for example, because I have no connection with Florida, he has no connection with Florida, and our dispute is based here in Washington, so we can't. Florida is not a proper venue for that dispute. There are some cases where you have a choice. So if it's potentially a federal, you have two parties in two different states, they can sue each other in federal court, even if it's over state law. And of course, if it's federal legal issue, it goes into the federal court system. The point is that part of the strategy of filing a case is picking the location that is most favorable to you, and then fighting if the other side tries to move the case to another jurisdiction. Okay. All right. Now, due process is a kind of big legal concept. Most of us should be familiar with it. That you have this due process right under the Constitution, and what we mean by due process is that you have the right as a citizen to proper procedure if the government is going to pursue a case against you. So it's here in the Constitution. It's actually in two places in the Constitution. It's the only concept that appears twice in the Bill of it's in the Fifth and the 14th Amendment, so two separate amendments to the Constitution. But basically, the Fifth Amendment says that you can't be deprived of life, liberty, or property without due process of law. So that means that the government can't just come and deprive you of your life, liberty, or property and not explain why they're doing it. They have to offer you proper due process. You have to be given the appropriate time. They have to be notified. You have to be able to argue your case, all of those things. The 14th Amendment says that the states have to do the same thing. So there's actually two kinds of due process. One is what we call substantive, and the other is procedural. So substantive due process refers to due process that has to do with, and here's a write-up about it, that has to do with the actual the substance of your argument. So you there's a sorry, I'm trying to read and talk at the same time here, but in 1905 there's this seminal case where a New York law that limited the working hours of bakers was found to be a violation of their due process because it deprived them of their right to work. Okay, so that's substantive to them, their right to work. Whereas in the procedural example, it is are you given enough time? Are you given an appropriate hearing? That's what we would call procedural due process. So if they say we're going to deprive you of your property, we're going to give you 1 day's notice, that would be a violation of procedural due process because you don't have enough time to respond. So that would be an example of that. In both cases, really what it means is, or the reason it's so important is because it protects your right against the deprivation of your life, liberty, or property by the government. So due process is a very important right that we all have under the Constitution. Okay, let's keep moving here. A forum. I mentioned this word a little bit earlier. You might think, well, what's the difference between a forum and a venue? And the forum is the particular particular kind of type of forum that you're going to use, whereas venue is the location. So there's down here there is a sample of what we would call a choice of law or forum selection clause. Is a very typical provision in a contract. And you can see here it says this agreement shall be construed and controlled by the laws of the state of Michigan, and the vendor consents to exclusive jurisdiction and venue in the federal and state courts located nearest to Oakland County, Michigan. And vendor waives defenses of lack of personal jurisdiction and forum nonconvenience. So that's what I meant earlier when I said you can't be sued in some faraway place. Well, if you sign this contract says that Michigan applies, that the laws of the state of Michigan apply, and that you have to, any dispute involving this contract would have to be in Oakland County, Michigan, in either federal or state court, and that the vendor, whoever it is that's doing business with this company, is waiving any argument that they don't have enough connection with the state to be sued there, basically authorizing the other side to sue them there. This is very common. This tells us that you can actually make, as part of your contract, you can pick what law applies and where the case is going to be heard. And if the parties to a contract agree to that, the courts will generally enforce it so long as there's not some other legal reason not to. So what would be that? Would be an example of that. Well, if you can't say we're going to hear our case about patents in a bankruptcy court. So if the contract said that the parties agree that the bankruptcy court's going to hear the patent case, well, that would not be enforceable because bankruptcy courts don't hear patent cases. But absent that, the location, the type of court and where that court is, the forum and the venue, is the parties are free to contract for that to be wherever they want. Okay. And let me just say one other thing about this. When I negotiate contracts, we spend a lot of time sometimes arguing over this. So my client will get a contract and it'll say, this applies in foreign examples too. We're buying something or selling something to someone who is in another country, and they'll say, well, we want the laws of Taiwan or the laws of China or the laws of Germany to apply. That's a very dangerous thing to do because we don't know what the laws are there, but that's enforceable if you sign that. So it's very important provision to negotiate correctly. Okay, so what is racketeering? You hear this term a lot in the criminal context. It is a crime, and the crime of racketeering is engaging in what's called an illegal racket. So what is that? So here's a good example of it. So not that I like to read from the screen, but this is a good definition. So racketeering is a criminal activity in which a person or organization engages in a racket. A racket is when the criminal creates a problem for others for the purpose of solving that problem by some sort of extortion. So the classic example of this is what we would call a protection scheme. You see a picture of Al Capone there. He's a classic mobster. The racket, a protection racket, is that the gangsters come into the business and they say, look, we're going to pay us a fee and we'll protect you. If you don't pay us that fee, then we're going to smash up your business. So it's a way of extorting a protection premium out of the business. And so that's the kind of activity that racketeering laws prohibit. Now, racketeering can be fairly broadly interpreted to mean any sort of bribe or extortion type of activity that's the common use of it. So you'll see racketeering in other examples besides organized crime. You'll see it in some white collar crimes as well. If it turns out that a business is acting in that way, there's a racketeering, possible racketeering crime when there is this engaging in an illegal racket. Okay, now we'll move on. Motion to dismiss. So we mentioned earlier a summary judgment. That motion is filed later in the case after discovery, but there's also an opportunity to dismiss the case earlier, very early on, in fact, right after it's filed, before there's any discovery. The parties can try to have the case dismissed, and this is usually the defendant that does this, although the plaintiff can file a motion to dismiss also if they want to withdraw the lawsuit. So if you look at Rule 41, Rule 41 says that it allows for what's called a voluntary dismissal. That's when the plaintiff would file it, or it can be filed by the defendant. And here are some of the reasons why you would file one. And they come from Rule 12, and Rule 12 is the requirements for a case to proceed. But you could dismiss because the court doesn't have proper jurisdiction. So like in my example earlier, if I filed in Florida, my neighbor could file a motion to dismiss based on lack of jurisdiction, that the Florida court doesn't have a right to hear the case. That's true in both subject matter and personal jurisdiction. The improper venue, so if you pick the wrong court or the wrong location. Insufficient process means that you didn't serve the other side, or the defendant never received the proper service of the lawsuit. So that's those two, 4 and 5. One is the service, and one is that the process, the document itself is flawed. 6 is the one where you see the most activity in a motion to dismiss, and this is where the defendant says, look, the plaintiff didn't state a claim that the court can't grant this. There's no claim that the court can grant where they could win. And so they ask the court to dismiss it before it proceeds. And then the last one is if there is some other party that should be in the case but was left out of it, then you can dismiss the case or ask for the case to be dismissed because it lacks a necessary party. Most of the time we think of lawsuits as one plaintiff versus one defendant, but complex litigation have plaintiffs and defendants, all kinds of them on both sides, and third parties that are involved in. They get really complicated. So there's parties that can be included or not included, and if you don't do that correctly, then that could lead to a motion to dismiss. So these are the grounds on which a defendant would request a motion to dismiss. The reason why the plaintiff might do it is because they just don't want to, they've already filed the case, but for whatever reason, they don't want to continue to pursue it. Either they realize they were going to lose, they ran out of money, whatever the reason might be, they can file a motion to dismiss it. And most of the time, if the plaintiff files a motion to dismiss, it's granted. If the defendant files it, they have this to meet one of the standards of one of those requirements in order to get the case dismissed. Okay. All right, let's move on to an injunction. This we kind of talked about already in a week before, so I'm not going to spend a lot of time on it. Trying to keep the videos already. Let's see, how are we doing? Oh, we're about right. We're about halfway through. Um, so an injunction is where you ask the court to ask or to require a party to either do something or to stop doing something. And we saw an example of this in the Napster case, where the recording industry won an injunction against Napster, and the court ordered Napster to stop its business effectively. It had a court order to shut down. So that was the end of that business. So that was a restraining order. And that's what we call injunctive relief, and that is a restraining order that can either be temporary, and temporary restraining orders are usually granted while the case is pending or to prevent further damage. And a permanent injunction or permanent restraining order is, of course, what it means. It means it goes into effect permanently. Okay. Okay, so after a plaintiff files the case, they serve it on the defendant, and then the defendant has a certain amount of time to answer it. So there's a filing of a complaint. That's what the plaintiff files and says, here's what happened, here's the money I want, or the relief I want, and then the defendant files an answer that answers the complaint. Now, if the defendant never files an answer, then the plaintiff wins by default. It's called a default judgment. So if you're ever served with a lawsuit, you don't want to ignore it. You want to file your answer. And it gets filed early on. And once you have the complaint and the answer, then the case is bound and then it continues on. And again, if there's no answer, it ends. So rarely do parties intentionally not answer because they don't want to have a default judgment against them. But most of the time, the defendant will answer. And it's usually a relatively short period of time, 20 days, 30 days. But most of the time, the lawyers grant each other extensions on those earlier filings. Okay, so the defendant, in addition to answering the complaint, can also counterclaim. And a counterclaim is where the defendant is suing the plaintiff over the same set of facts. So there's a claim and a counterclaim. So give you an example of this. I have a client, actually a friend right now, who is involved in this, and he sued the other side for non-payment, and then the other side sued him for fraud, claiming that the reason they're not paying is because my friend committed fraud. So it's a tactic sometimes that's used as an offensive defensive strategy. So it does require the same events. It involves the same events. It can't be some other random dispute that they have. That would have to be in another case. It has to be a claim connected to the same set of facts that the plaintiff filed about. And the idea here is that all of the issues are brought forward for resolution. So the idea is the court doesn't want to hear one case on this, go through the whole system, and then have the other side sue back, have the defendant sue the plaintiff in another case, and just goes on and on. The idea is if there is any claim associated with a set of facts, you have to bring those in that same litigation. And this is actually wrong here. I'm going to fix this. Oops. Uh-oh. What did I do wrong here? Hold on. Okay, then I think I hit escape, right? Yeah. Who files it? It's the defendant that files the counterclaim. All right. Oh, shoot. Sorry. Presenter view. Okay, there we go. All right. Sorry, I'm trying to figure out how to do all this stuff. Okay, so that's a counterclaim. All right. So I mentioned earlier I would explain what is civil procedure. What does that term mean? Well, civil procedure means the entirety of the set of rules that govern the procedure of a case from filing to all the way to trial and even on to appeal. And so this is a really nice timeline graphic that I found online, and if you'll have these slides and you can click on this and see it. It's a little bit bigger. But what's nice about this is it kind of shows you all these different stages of a lawsuit, how it's filed, and then the complaint is served. This is what we just talked about. And then sometimes the discovery starts right away, but usually the defendant files their answer, and often will then also try to get it dismissed early on. Then you go to different kinds of discovery, which we'll talk about in a minute. And so discoveries where you collect information about the case and get ready for trial. And then over here, you end up having your discovery is cut off. That's when you would have your motion for summary judgment. And then if you're going to try to settle it, you have your mediation to do that. And then you have one last meeting with the judge, and then you go to trial. This timeline in many cases is years. It could be years. It's at least a year and a half in state court in the state of Washington. But some cases can drag on for years and sometimes even decades, depending on how complicated they are. All very, very, very expensive. So that's why it's important to understand just how many pieces of the puzzle are involved from the time you file until the time you potentially would win a jury award. It's a long time. And as we will talk about in a little bit, it doesn't mean that you collect your money. You could win and still not be able to collect. Okay, so that's a good chart I would recommend you taking a closer look at. Okay, so I just mentioned discovery. So what is discovery? So discovery, again, is this collection of information for the case. It's where both sides collect up the facts that they're going to use to make their arguments. And you do that through several different methods. So one of them is a deposition. And a deposition is where you get the other side to come into a conference room and you question them like they're in court. And you can ask them, and they're required to answer these questions, and then you use those facts as part of the case. So, and I think I have a video to show you on that later, or to point you to. That's kind of funny. But so that's what a deposition is. It's basically evidence given in person, and it's usually recorded and transcribed, and then it becomes available as part of the evidence package of the case. Either side can also then request the production of evidence documents, and this is where discovery gets so expensive, because I was involved in a case not that long ago, and their discovery request was for every single email ever written between party A and party B between the two dates of so it's like thousands and thousands and thousands and thousands of emails. And now there's this whole industry called the e-discovery industry, and these companies that sell software that goes out and finds all of the information that has been requested in a case. Interrogatories are the written version of depositions. So you have a chance with an interrogatory to say to the other side, you can ask them questions, and you do so in writing, and then they respond in writing. That is usually done before the deposition. It's a way to get initial responses to questions. There's a lot of arguing over these. You get the first set of interrogatories, and it's just hundreds of pages of all these questions, and many of the questions are answered, this question's too vague or too broad, we object to it, and so then they have the parties fight over whether that's an appropriate interrogatory or not. And again, this is why this all becomes so expensive, because you have this back and forth requests for information, requests for paper, fighting over whether something should be turned over or not. And then the last one is requests for admission. And this is where the idea here is to make the trial more efficient. So if the case is over a contract and we're not disputing that the contract exists, then what we would do is the two sides would admit or stipulate that they had entered into the contract. And then we don't have to present evidence at the trial about that fact because it's already been admitted by the parties. So that's called a request for admission. There's also something called a stipulation where the parties just stipulate to a given fact. Now, the contract was signed on June 15th, 1999, period. And we both agree to that. So we don't have to admit evidence to the record to show when it was signed. We just agree to it. So that's a way to make the discovery process more efficient. But of course, the parties will argue over certain things if there's a strategic reason why you want to delay or make the case more expensive for the other side. Okay. All right. So attorney-client privilege. If you're not familiar with what this means, it is a rule that says that a lawyer, and these rules apply to me, the rules of professional conduct, is required to maintain the confidentiality of certain kinds of communications from a client. And the reason why we have this rule is that if we didn't, then clients wouldn't be honest with their lawyers. So if in preparation for a lawsuit, the client comes to me and says, here we did an internal investigation. This is what we found. This is really bad. What do we do about this? Well, they're not going to say that to me if they know that piece of paper will be discoverable. So certain kinds of documents, if they fall under the attorney-client privilege, are not discoverable. The other side does not have a right to see them. Now, in discovery, you still have to disclose that they exist. So it's called a privilege log, where you keep a log of every document that you are claiming privilege for. So they know it exists, they just can't see it. And there's obviously fights over whether those certain documents have to be turned over or not. And this relates to the work product doctrine. So what the work product doctrine means is it's slightly related but different than the privilege. So if I am producing work for my client in anticipation of litigation, then my work product is not discoverable. So if I take notes, if I review documents and take notes, or I'm interviewing my client to find out what the facts are, my notes, and if it's done, it has to be done in anticipation of litigation. So that you can't just exempt everything. It's only documents that are created in anticipation of litigation. Oops, there's Justin Bieber, who we're going to see in a minute. And so it can only be for that litigation. And if the document is protected, then it's the document that's protected, but not the facts. So if the plaintiff, the other side, finds out about whatever it is that's in my notes, that isn't protected, but my notes are. So they can't get to that information through the notes produced by the lawyer in anticipation of the litigation. Okay, so now I'm sure you want to know why Justin Bieber's on the next screen, and it's only because we talked earlier about what a deposition is, and I will let you watch this on your own, but I think this is really funny because this is an example of a deponent, meaning someone who's being deposed, who is not very cooperative, and it's really funny what a jerk he is in this deposition. There's other videos of him being a jerk in depositions too. Apparently he gets sued a lot, but it's funny to watch if you have a moment. So how is it used in a lawsuit? Well, this is how you discover information. You ask specific questions of the other side, and they can't avoid them. They have to answer them. They can object, but they still have to answer. Whereas in trial, if an objection is sustained, then they don't have to answer because the jury could possibly be prejudiced by that. But in the deposition, they still have to answer. So depositions are very valuable tools for getting the other side of the case to putting them under pressure to answer the specific questions about the facts of the case. So this case with Justin Bieber had to do something with his bodyguards and whether he's liable for some damages that they caused. So it's pretty funny to see how what a punk he is in this deposition. Okay, so what is a contingency fee? Now, most of the time in the business context, you will not encounter this, at least as a plaintiff. When you hire your lawyers, you will generally pay them for their time. Now, if you're a plaintiff, for example, in a class action case like we talked about earlier, and let's say you have the example of the million people who each lost $1. Well, they're not each going to pay 10 cents or whatever it is towards the legal fees. So what they do instead is the lawyers take the case on contingency, which means they don't get paid unless and until there is a judgment, and then they collect a piece of it. And in many cases, that piece is 30 to 40%. That's true in personal injury cases. In fact, this link, I think, if I remember right, talks about personal injury cases and what the kind of standard rate is. But see, it says here most personal injury lawyers charge 1/3 to 40%, and most employment lawyers charge 40%. And the reason they do this, besides the fact that they're sharks, is that they don't win every case, and they have to pay their people and their rent and their insurance and everything. And it could be that they do all that and lose, in which case they don't ever get paid. So the ones they win have to pay for the ones they lose. And it has to be has to be interesting to them. Otherwise, why would they risk doing it? So lawyers take these cases because they offer a fairly large payout. I have a friend who does some personal injury work, and what he says is that he pays his rent doing the kind of work I do, like contracts and trusts and wills and things where a client comes in, you do the work that you get paid, and he uses that to kind of pay his expenses. And then he always has a number of personal injury cases going, and that's where he makes all of his money. Wins $1 million case, and he just made himself, $300,000 or more. Okay, so that's a contingency fee. Now, as a business owner, how might this impact you? Well, you could be on the other side of a contingency lawyer. You could be being sued by one, which means that lawyer is incentivized to extract the largest possible dollar amount because they're going to personally get paid more. So when you are facing a contingency fee lawyer, it can be kind of a nightmare. And you're paying, by the way, you'll be paying your defense bills. There's no defense counsel that takes a case on contingency. So when you're the defendant, you're paying all the costs to go through all this discovery and everything, and the plaintiff's lawyer is incurring that cost and hoping to get reimbursed by extracting money from you. Okay, I think we already talked about punitive damages in a previous class, but I put it on here anyway, just because I wanted to reinforce that these are damages that you can seek in addition to recouping what you lost. And they are for the express purpose of sending a message, trying to prevent future bad behavior, but it does require a higher level of, you can't just win the case and win punitive in most cases. There are some examples where they're in the statute and they're automatic. But for the most part, like in torts cases, in order to win punitive, you have to prove that the defendant acted either with willful or wanton intent to cause this harm. So it's a pretty high standard to win that. And as a result, they don't get awarded very often, only about 5% of the time. Okay. A preemptory challenge in a jury selection case. So if you've ever served on jury duty, which I did once, in my undergraduate class, I used the example for when we talk about torts. And if you're interested, I only say this because it was it's my 10 minutes of fame, 48 hours, the soldier's wife. Okay, this is the case. All right, this is the case of Skylar Nemitz, who killed his wife in their apartment. I was the juror on this case. I was actually the presiding juror, and then they did, meaning the foreperson, and I ended up being. They did a 48 hours episode about our case, and this is the 48 hours episode about it. And so what happened was, as they decided, they knew this was going to be a big case. They knew this was going to, there's a stupid commercial here. They knew this was going to be it was in the news, and was going to be on 48 hours, all this stuff. And so they started with over 100 jurors before they selected the 12 of us that became the actual jurors. And what they do is, let me see here if I can just show you this. I don't know if it'll let me fast forward. Oh, it won't. Anyway, you can look it up yourself, and in the last 10 or 15 minutes is the part that I'm in. So if you want to see me on TV. All right, so what happens is if a juror says, if the person who's on trial is a minority, and the person says, yeah, I'm prejudiced against that minority, those people get dismissed. The judge dismisses people like that. If they know the defendant, or if they know the lawyers, or if they have some other obvious reason why they shouldn't be on the jury, they get dismissed. And then after that, the lawyers have a certain number of these preemptory challenges, which means the lawyer can, each side can dismiss up to the maximum number, whatever is set for that case, of jurors, no questions asked, just because they think maybe they're not favorable to them. And so the process of jury selection, if you've never gone through it before, after all of the dismissals for cause are done, then the lawyers have a chance to interview the potential jurors, and they have a chance to dismiss a certain number of them just because they don't want them. And there's a whole science behind this. There's a whole consulting business. There are these jury consultants who advise lawyers and defendants on who should be on a jury. So that's what a preemptory challenge is, and that's how it differs from a dismissal for cause. Okay, we only have a couple more here. We've already, I think, talked about this one. I just wanted to show you this because just to remind you when we are talking about what we mean by an appeal. An appeal is a filing after the trial court. So after the lower court case, after the trial court, the losing party can appeal to an appeals court, and there's always one appeal that's you're permitted. The only case that can't be appealed is a criminal case where the defendant is acquitted. If the defendant is acquitted, the state can't appeal the acquittal. Now, if the defendant is convicted, then the defendant can appeal the conviction, but the prosecution cannot appeal an acquittal. But in civil court, pretty much every case can be appealed, and not only the case itself, but even issues within the case. So it is possible, and often does happen, that the parties will, in really complex litigation, will sometimes appeal multiple times during the same case of different issues within the case. This is why these things drag on for so long, and that's why they're so expensive. Okay, all right. That's it. We actually made it through, and wow, I did this. The clock time on this is 54 minutes, so just a few minutes over what would have been the class period for the key legal concepts, the class time that I normally allocate. If you have any questions, please post them to the forum. I know I went through some of these kind of quickly. Some of them we talked about before. But if you have a question or want to discuss any of the items that were in this video, please post them to the forum during this week, and it'd be great if we could get kind of an interesting discussion going on that. Hopefully that will work for you. If you have any direct questions, please feel free to email me. If you would like to meet with me, I'm available by Skype or Zoom or Google Hangouts or phone or whatever it is that you need during this time when we are not meeting in class, please feel free to contact me. I'm here to help. Okay, thanks for watching, and the next video will be the one where we'll go through the shell chapter. All right, thank you.